Wait for it. Meg breathless as UK tabloid hunted her down after forced to fake apology. On Sunday, December 26, the Mail on Sunday printed an apology to Meghan Markle. They were required to issue the statement after losing a lengthy court battle to Markle for breaching the Duchess of Sussex's privacy. Following a hearing on 19th-20th January, 2021, and a further hearing on 5 May, 2021, the court has given judgment for the Duchess of Sussex on her claim for copyright infringement, the statement said. The court found that Associated Newspapers infringed her copyright by publishing extracts of her handwritten letters to her father in the Mail on Sunday and on Mail Online. Financial remedies have been agreed. Meghan Markle can rest a little bit easier now that her 3-year court battle against the UK publication The Mail on Sunday and its website Mail Online has come to a close, with the Duchess victorious. The lawsuit, over privacy and copyright infringement, stems from the publication in February 2019 of a 5-page private letter Meghan sent to her father shortly before her wedding to Prince Harry. The publishers of the Mail on Sunday and Mail Online were required to print a statement acknowledging Meghan's legal victory after losing a lawsuit. A UK newspaper was forced to print an admission that it had violated the rights of Meghan, Duchess of Sussex, on Sunday after losing a privacy and copyright infringement lawsuit. On February 11, High Court Lord Justice Mark Warby ruled in Meghan's favour in a summary judgment, a type of verdict granted when a judge determines that no trial is needed because the evidence is so overwhelming. In his decision, Warby wrote that there is no prospect that a different judgment would be reached after a trial. ANL's lawyers appealed the ruling, claiming that Warby was wrong to award Meghan victory via summary judgment and arguing for the right to present their case at trial, something the Duchess has fought against from the beginning of the proceedings. To permit the defence to go to trial would only have facilitated further invasions of Meghan's privacy, her lawyers wrote to the UK Court of Appeal in November. Meghan's legal team accused ANL of pushing for a trial because it would give the tabloid company the opportunity to profit handsomely from the media circus that would inevitably result. During the appeal proceedings in November, lawyers for ANL argued that Warby made his judgment without knowing all of the information, and presented new evidence in the form of written testimony from the Sussex's former communications secretary Jason Knauf that showed inconsistencies in Meghan's statements to the court about the letter and her expectations of privacy. According to Knauf, Meghan composed the letter knowing that her father might give it to the press. And although Meghan swore under oath that she never coordinated with members of the media to share private information, Knauf provided the court with emails between himself and the Duchess discussing what she wanted him to say in a secret briefing with 2 reporters who were writing what proved to be a very sympathetic biography of the Sussexes. In response to Knauf's revelations, in a witness statement filed November 11, Meghan apologized to the court for the fact that she had not remembered these exchanges and swore she had no intention to mislead the defendant or the court. However, the fact that Meghan, intentionally or unintentionally, was not entirely truthful ultimately had no effect on the Court of Appeal, which ruled in her favor in a judgment issued December 2. Although ANL said in a post-verdict statement that it was considering appealing the case to the UK Supreme Court, its publication of the apology Sunday signalled that the company has finally admitted defeat. As part of his initial judgment in Meghan's favour in February, Warby ordered ANL to publish a statement in print and online that acknowledged the company violated the Duchess's copyright rights. According to UK law, where the court finds that an intellectual property right has been infringed, the court may, at the request of the applicant, order appropriate measures for the dissemination and publication of the judgment to be taken at the expense of the infringer. As can be seen in an order filed by Warby on March 22, the wording and format of ANL's statement was a source of contention, down to the font size in which the text would be printed and how long the statement would remain on Mail Online's website. The agreed-upon text was published Sunday on the 3rd page of the newspaper, with a statement on the front page directing readers to it. The same text, with links to the court's judgments, is currently on display on Mail Online's homepage and will be for the next week. Many commentators pointed out that ANL chose to carry out the court order the day after Christmas, a day when few people typically read newspapers. To present their case at trial, something the Duchess has fought against from the beginning of the proceedings. To permit the defense to go to trial would only have facilitated further invasions of Meghan's privacy, her lawyers wrote to the UK Court of Appeal in November. Meghan's legal team accused ANL of pushing for a trial because it would give the tabloid company the opportunity to profit handsomely from the media circus that would inevitably result. During the appeal proceedings in November, lawyers for ANL argued that Warby made his judgment without knowing all of the information, and presented new evidence in the form of written testimony from the Sussex's former communications secretary Jason Knauf that showed inconsistencies in Meghan's statements to the court about the letter and her expectations of privacy.